Okay, well, good afternoon, everyone from Auckland. I'm delighted to be able to participate in this panel today, virtually at least, with Lana and Matt. I'm very grateful for the invitation. New Zealand lawyers have been subject to AML, CTF, or CFT as we call it, since 1 July 2018. There were some significant changes that were required for the New Zealand legal profession when AML rules were introduced for lawyers. And it will be fair to say that in this country, the regime occurred with a lot of haste following the publication of the Panama Papers and a subsequent report in relation to the use of foreign trusts and the facilitation of those foreign trusts by New Zealand lawyers. The regime that was introduced in New Zealand essentially simply repurposed the existing regulation of financial institutions and applied very similar rules to the New Zealand legal sector. It didn't differentiate between different types of lawyers, and so from 1 July 2018, barristers and firms of solicitors, sole practitioners, were all subject to a single set of rules that were very activities focused. So if in the ordinary course of business, certain activities were being carried out by practitioners, they became subject to these rules. In relation to real property transactions, the use of trust accounts and undertaking conveyancing work, undertaking real property work of all kinds, including mortgage activity, financing, obviously transfer of title, subdivision, development activity, all came within the ambit of the AML rules. Other activities could also bring a lawyer within the anti-money laundering rules, and they would include some of the representative functions that lawyers might from time to time undertake, such as operating as a registered address or providing a correspondence address or even an address for service. It could also apply if the lawyer was acting as a trustee or a nominee for a client. Now, if the AML regime applies, it does create significant new compliance obligations for a law firm. For a start, a law firm is going to have to undertake an internal review of the kinds of risks to which its business is subject, and it will need to put a program in place to state how it's going to manage those risks. Law firms will also need to have a framework for reporting, both internally to give approvals for certain types of activities, and to report externally to the FIU for certain types of suspicious matters. Records need to be kept. There is the potential for audit and for supervisor oversight of AML obligations. What we found is that there's a significant amount of effort and money that's required by law firms, both to look at the risks and put a program in place to start off with, but also on an ongoing basis in terms of ongoing due diligence activity, supervisory activity to make sure that existing files are reviewed for further risk, and just in generally an internal compliance function. There are also implications there to make sure that lawyers have the right kind of culture, because the AML regime does require quite a shift in approach. Whereas lawyers are traditionally not inquiring about where their client's money has come from, not necessarily checking where a specific payment has been sourced, or, for example, where money has come from an inheritance, or sale of a business, or some other transactional source. We're not used to asking those questions of our clients. And so that kind of thinking and that kind of questioning is something that is you're going to have to think about and you may well face. It's frankly quite uncomfortable the first time you've got to ask the client, well, actually, where has that money come from? And so that's something that you just will need to consider. The requirement for AML to obtain and to verify information about clients is already probably partly occurring in practice. That same type of activity may well suffice to satisfy the AML regime. There are some exceptions that were brought in for New Zealand to allow a fairly soft start to the AML regime. For example, existing clients did not have to have due diligence undertaken on them, although they did need to be reviewed over time, and that was to enable a relatively soft start for the regime. So one hopes that when AML is introduced in Australia, there's a similar kind of approach. As I understand it, currently there is no requirement to undertake a great deal of inquiry about the controlling persons behind a client. Typically, with a corporate client, a lawyer might look at the asset record and might get information about who the directors are, but they won't be undertaking any further inquiry about who the controlling shareholders are. In New Zealand, we're required to ensure that if we have more than, or equal to or more than 25% shareholders, that those people are identified. We also need to undertake checks on the directors to make sure they're not just nominee directors. And we also need to look for anyone else who may have effective control over a client. Trusts and more complex structures have an even higher level of inquiry, and that includes inquiry in relation to the source of wealth, the source of funds of the trust. The inquiry then extends to who the trustees are, who the beneficiaries are, unless there are more than 10, in which case class of beneficiaries may need to be identified, and any other person, such as a protector of a trust, must also be checked. It's important when considering what all of this might mean for an Australian practitioner, Queensland property practitioner, to think about a few things. Are we acting in the course of this AML CTF regime as unpaid informants for the state? What are the obligations that we have? Who's paying for this? Are we doing it, or is our client paying for it? And if so, how do we price it? Will I need more staff? Will I need to get some exterior help to document my risks and to understand my compliance obligations? And what support can I get from the Law Society, from Lexon or other insurers, or from other third-party providers to help me understand my risks? Can I repurpose existing procedures, including HERB, ATO, state revenue, local authority, CRS and FATCA, information collection obligations? Can I repurpose that stuff to use for my AML obligations, or can I turn it all on its head and get the AML information up front and then use that for my other processes? How, on a risk-based approach, do I best manage my AML risk? Have I really got any risk, or am I actually in a low-risk situation? And how do I best create and maintain a compliance culture for myself and my fellow practitioners? So those are some of the questions that I think we're going to need to consider with an AML CTF regime as it comes in and as it might apply to the Queensland property scene. Thank you.